Can I first of all please introduce the panel to you? We have Dave Hill. He is the past president of the Association of Directors of Children's Services. That's effectively a shorthand way of saying that he comes to this panel with a remarkable degree and knowledge in terms of children's services and those of the most vulnerable in society. Dave has worked in local authorities since 1977. He originally trained as a social worker, and he then expanded those skills, working as an advisor in organisations such as the Tavistock. And when he became past president of the Association of Directors of Children's Services, he used his inaugural speech as director to demand a debate about the limits of state interference in family life, saying plainly that, and I quote, "We intervene too often and sometimes too readily in family cases." That's the calibre of the man that sits before you. We will also be hearing from Sanchia Berg. She is a BBC journalist of the highest order. To those of you who are addicted to Radio 4, you need to know that Sanchia is one of the leading lights of the Today programme. Not only is she one of the contributors on Air and Behind, but her journalistic groundbreaking work has really brought the question of abuses of power to public attention. Simply two to mention, I think, and I could go on forever, but she was the person who broke the story of Savile, No More Secrets, which was a Panorama programme. She was longlisted for the Orwell Prize in exposing Britain's social evils category for her work around mothers involved in care proceedings, and her work investigatively behind the scenes for Panorama, as I've said, and the Today programme is ongoing. We welcome her. We have Gill Phillips. Gill is Director of the Editorial Legal Services for The Guardian. Her coverage is exemplary. She's been praised in many a paper. She joined the BBC as an in-house lawyer in 1987 before transferring her skills to The Times. She moved to The Guardian, as I say, in May 2009, and her work encompasses phone hacking, WikiLeaks, the NSA leaks from Edward Snowden, and then more recently, the HSBC files and Panama Papers. She regularly advises on open justice issues and court reporting restrictions. Just in case you think that there should be more to a journalist than simply having that CV, can I tell you that she also sits as a part-time employment tribunal judge, and she co-authors the College of Law Employment Law Handbook. Brian Farmer, very welcome tonight. He is the Press Association reporter who regularly reports on the family courts. There is very little that goes on in the court system that Brian does not know. He knows more than he says, and for that we applaud him, because his measurement and in terms of how he reports what he hears has warranted praise from many a High Court judge, recently being praised in one High Court case for responsible journalism of a very high order. Brian represents a standard of reporting that we wish could be seen across the media more broadly, and he is very welcome to this panel. We have Will Moy, a director of Full Fact. He is effectively our Fact Wiki leader checklist. We cannot do without people like Will, because they are the people who check what goes into the public domain and correct those misreportings that otherwise would have a different life when they get to be repeated through social media. He fact-checks claims made by politicians, interest groups, and of course his colleagues on the media themselves. He's been director of Full Fact since 2010. That means he's taken us through 3 referendums, the Leveson inquiry and the 2015 general elections, and of course we are in turbulent times now with Brexit. We have Debbie Singleton. She is very much a friend of the FLBA and the organisations with which us practising lawyers work. She's specialised in family law since she qualified in 1994, and she has extensive experience in representing children in private law proceedings. As if that wasn't enough, she is co-chair of the Association of Lawyers for Children, the ALC, and director of Family Legal Services for NIAS, the National Youth Advocacy Service. Her creed is to be committed to promoting the rights of children and ensuring that the voice of the child is heard in all matters affecting them both inside and outside the court arena. We have Lucy Reid sitting to my left. Lucy is a barrister at St John's Chambers in Bristol, and she won't say, but I will. Lucy was Bristol's Law Society's Barrister of the Year for 2016. That is because not only is she superb in court with what she says and does, but her work for the FLBA is beyond compare, and she has garnered many praises for those who see her work inside and court at the highest order. It is extraordinary to me how, as a woman and a wife and a mother, she is able to blog to the degree of excellence that she does. Her Pink Tape blog is one you should follow if you want to know what's going on in the family court system. And she's also author of the Family Court Without a Lawyer book, which is essential reading for anyone who's thinking of walking through the court doors without a lawyer to represent them. Last but not least, and I say this with some trepidation, we have Mr. Justice Peter Jackson. He is a man who was a colossus at the bar before he was appointed. He was called to the bar in 1978, took silk in 2000, became a Deputy High Court Judge in 2003, and has been a judge of the Family Division since 2010. His case reporting is known for its succinctness and its directness. When you appear before him, you tremble, because he takes few notes and yet seems to have a remarkable recall for everything you say, facts, mistaken facts and opinions included. The public may know him because of a judgment that reached the press in all the right way. There was a succinct, concise, beautifully written judgment, written in language that the children who were the subject of the proceedings could understand, aged 10 and 12. It did away with Latin, it did away with jargon. It explained succinctly and clearly and straightforward terms why these children were in the care system and what risks their father presented to him. If we could express things so succinctly and simply and clearly, then the family justice system would be all the better. On a lighter note, he's also been known as my hero, Peter Jackson, by the young girl who was the subject of the cyanogenics case that hit the news lines. Judges seeing children is still not as frequent as perhaps it should be. But for Peter to go to the lengths he did, including going to see this young girl in hospital, explaining the decision-making process and what it was about, shows a level of dedication to public service which is exemplary. So these, ladies and gentlemen, are your panel this evening, and it's a delight to welcome them. What I'm going to do now for May is to hand over to Lucy, who's going to explain a little to you about what the Transparency Project is. So we'll just make sure while the roving mic moves to her. Can I just say that none of us as lawyers are actually used to using a mic. We have this old-fashioned belief that if we shout loudly enough, then we might be heard by everyone in the court system. So the mic is going to be a slight experiment. Bear with us if it starts to double hum, and whilst we pass the baton between the front table. So Lucy.
Hello, good evening. I just wanted to tell you a little bit about the Transparency Project, because it's the Transparency Project that are putting on this event tonight. And it may be that some of you have heard of us, and it may be that some of you are here because you were told about the event itself and you don't know what and who we are. We are a charity that was formed in 2015. We're essentially a group of volunteers who are trying to help make family law clearer. We're doing the best we can alongside our day jobs in most cases, and we're now fortunately part funded by the Legal Education Foundation, which helps us do a bit more of what we've been doing since 2014 informally, and then since becoming a registered charity in 2015. We're a group of academics, lawyers, journalists, publishers, all with an interest in family justice, family law issues, and we spend our time correcting, clarifying, explaining cases and trying to encourage better practice in terms of reporting. And we're also engaged in a learning process ourselves in trying to understand how reporting works so that we can better support good reporting. Our Legal Education Foundation funded project, Family Court Reporting Watch, has been running since October last year. Really, that's more of the same. When cases are coming up, either they're published on Bailey or they're reported in the press, we're trying to make sure that the public have accessible information so that they can understand both the judgment, the law, and indeed the reporting or misreporting of those cases. And we're trying to spread those blogs and pieces of information that we publish as widely as we can. Alongside doing that in the moment work of responding to cases that are topical or that are legally interesting, we have also been producing a series of guidance notes which are aimed at tackling hot topics or problem areas, which we've identified from chatter on social media or talking to people involved in the family justice system, whether that's professionals or family members or campaigners. And we've produced those guidance notes. We're now funded through LEF to produce some more of those guidance notes. But one of the ones that we've produced is the media guide, and that's what we're here to launch tonight. That was the initial impetus for this event, and later on this evening I'll tell you a little bit about the media guide. But this event has taken on a bit of a life of its own now. We're really pleased to see so many of you here. The last thing I want to say before we get going properly is this. Please have your phones on silent, but please don't put them away, because we would encourage you, if you want to tweet using hashtag #ReportingFamilyJustice. And you'll see from the document that's on your seat that we are a charity. We have limited funding. We've been able to make this event free tonight because the FLBA have very generously sponsored it, and we wanted to make it free so that it was accessible and we get good, wide attendance from a range of different people. But if you do feel that this has been a good event and that there should be more events like this, then if you can donate, that would be fantastic. That's the blackmail done, and I'm now going to hand back over so we can start properly. Thank you very much.
Right, so in order to earn their spot on the top table, each of our panel speakers was asked to do a short response to the question of reporting in the family courts, are we doing it justice? And so we can see whether they've done their homework. Each of them now will give you a very short answer to that question. It should be something that engages you, we hope, and something to get questions coming from the floor. So whilst you're here in the panel, give their answer to it. Think about what you want to ask. As I say, you've got the paper down there to write, you've got your hand in order to raise to the air. This is your time to think and reflect, so you're ready to rock and roll with the first question once we've gone through the front roll. Lucy, you've just spoken, so I am going to dart along to the end. Elegant as a gazelle, not, to pass it over to Peter.
Thank you, Jo. I was in fact asked just to say one sentence, so that's what you'll get, but it has some commas in it. This has been going for 3 years in terms of the publication of judgments, which is one aspect of the matter, and my view would be that that represents a worthwhile start in a sensitive area, and that now is the time to take stock of where we've got to. There have been some useful pieces of research, and this evening's gathering is, I hope, another opportunity to inform about what we should be doing next. That's my contribution at this stage.
Thank you. Sanchia?
Yes, I'd say it's very much a work in progress. I think we do report more from the family court since judgments are now more frequently published, but I think also we are able to report some of the broader themes and discuss some of the issues and problems in a way that we didn't before. So all of that's positive. But I also think that, as Julie Doughty pointed out in her research, it's all very piecemeal. So the big thing that we can't do, for example, is compare local authorities. Which ones are doing well, which ones are not doing well, because the picture that we have is so patchy and inconsistent, it has very limited use. So there is that frustration that while you get these individual stories that are very interesting and do help inform people about the way the family courts work, you're not able to grasp the bigger picture or tell people about the bigger picture.
Okay, good evening. Well, my short answer would be no, and if that's not a language people understand, that would be what I would say. I'm going to read tomorrow's family court list in Court 42 before Mr. Justice Peter Jackson. It says, applications in court as in chambers, LV 1730062, FD 17P00090. Most reporters don't have the faintest idea what that means. Now, we know we can go into the family court shops, and we know that sometimes we can take away a present. What we don't have any idea generally is what the family court shops are selling. If we're going to do justice, some way has got to be found of putting better signs outside the court so we know whether we want to come in and shop or not. Because all too often we will simply go away and shop elsewhere.
Thank you. Just to correct one point, as this is about factual accuracy. I'm a lawyer, not a journalist.
Oh, it's all right.
That's okay. So that's how I speak. I mean, I can do nothing better, really, than echo what Brian said. with a financial caveat on that. Journalists who go into courts and sit there and are then unable to report days and days and days are not going to continue to go into courts. So there has to be something that allows them to make an informed decision about what they're going into and what they might get out of it in terms of producing copy. So my short answer to the question was things have got better, undoubtedly, but it's been slow and there's still a long way to go. And there's a shared responsibility on all the people involved in this, judges, lawyers, the parties and the media, to continue to make this a much more transparent process.
So put simply, I think I wanted to say this, that there is, in my view, a direct calibration between openness, transparency, and the credibility of the family justice and court system. And unless we can develop that further, I'm afraid the credibility will not be extended, not just to journalists and to lawyers, but actually to families and children and local authorities and social workers and all the people involved in the process.
It's not a yes or a no, really. The President said that we need to ask children and young people, because they're the experts, ask for their views. And at the ALC and at NIAS, we did exactly that. We went and asked young people with the work through Julia Brophy, and we consulted them, and they were quite clear about the need for their privacy to be respected. And having regard to the Children Act, we should have regard to their ascertainable wishes and feelings, which were very clear on the point.
Starting from Full Fact's point of view, I think Full Fact needs to do much more. We got our legal team, both of whom are here, Joshua and CJ, a few years ago, and we've mainly been eaten by Brexit and the elections. We would like to be doing more of this work. But let me ask the question of what happens when things go really wrong. When we have great specialist experts explaining things and great specialist journalists explaining them to the public, then we have the ingredients, at least, of getting this really right. When it goes really wrong, who can step in and intervene authoritatively to stop it? Disinterested organisations like media organisations and like Full Fact have a role in that. But where is the authority? In the field of statistics, if somebody says something seriously wrong in public life, the UK Statistics Authority is there to step in and ask for a correction and explain what is actually going on. I wonder if, with the way information now spreads, not always through major media outlets, not always through edited outlets, there is a role for the expansion of the law officers' public interest roles. They already intervene in a number of public interest ways, such as challenging overly lenient sentences. Is there now a point where the law officers should sometimes be willing to intervene and say, the law here is being widely misunderstood, and as an independent law officer, I will set out what the law is? I think maybe that would be a useful expansion of their role from time to time, not constantly blowing a whistle like a referee.
I set this task. I said, do a sentence and don't say yes or no. I'm going to fail my own test. It's not the media's job to do PR for the family justice system, but it's the job of everybody in the family justice system to do what we can to promote public trust and confidence in that system. And that we do that in two ways. Firstly, it's by judges making good decisions. Secondly, it's by showing workings, insofar as that's compatible with the welfare of the children that are being dealt with. But I'm really troubled this week, in particular, if the level of public trust and confidence in the family justice system is as described in things I've been reading on social media this week about particular cases that are hot in the news this week, then we're really failing, because the level of public trust and confidence in our family justice system as being described on social media is rock bottom. So I think the issues are far wider than the quality of mainstream media coverage. The whole social media issue, we need to grapple with it.
Okay, right, thank you very much. So a range of views there. I'm going to take the privilege of chair to ask a question, first of all, I think, of Peter, if I may, which is to answer the question as to why in the family justice system we are so careful about reporting details of the children and the families involved, so that we have a basic platform upon which to start the debate. Peter, I wonder if you could just explain what it is about the cases that we deal with that means that we are cautious and careful about revealing details of the children involved.
It'll be obvious to everybody here, because they're here, that one has to be important before throwing families effectively to the wolves, throwing children to the wolves, simply in order to burnish the reputation of a court system. Those who represent the media will always rightly argue for more openness, and better systems. And we can always think of ways to achieve that. Those who represent children will obviously see matters from a different perspective and will rightly argue the point of view of the children. So where does that leave the system? Somewhere between the two. And I'm not here in order to say that the way that things are done at the moment could not be improved. Obviously it could. And I think that we now have enough data to begin to look at how we could do things better. But provided I find myself somewhere between the children and the media, I will probably think that I'm approximately in the right place. There are real concerns about identifying children to their peers, identifying children to their neighbours, quite unnecessarily in a way that, because these children will largely be at a disadvantage to start with, because they're involved in care cases or they're involved in difficult private law disputes, can only add to their problems. And so that's on the one side. And on the other side, we need to allow responsible journalists particularly, but also irresponsible people, to form their views and to broadcast them. So I don't feel that we're likely to be able to move very far from where we are without causing unintended consequences and damaging people who need protection. I think that if you think about it not just as individuals, as professionals, if you are interested people generally, but you think about it from the point of view of you, your family, your children, then you'll answer Joe's question for yourself.
Thank you very much. Now, any questions from the floor? Thank you. Joshua.
Can I pick up Will's question? I must declare an interest because, as Will said, together with CJ McKinney, I work for Full Fact, which is the organisation that Will heads. CJ's on the staff, I just contribute. And I just want to give you the example of a story which appeared in the Sunday Times just over 2 weeks ago. It wasn't a family case, but it wasn't a million miles away from it. It was the story that rape victims or alleged rape victims wouldn't be cross-examined in court. They could give their evidence ahead of a criminal trial and be cross-examined then. This story was not true, but it was based on a briefing from the Ministry of Justice, which was not true. And so the Sunday Times published it in good faith. The next day, the Lord Chief Justice wrote to the judges to say the story was not true. The first we heard of it was 2 days later when he was giving evidence to the House of Lords Constitution Committee, and he told peers the story was not true, and we doorstepped him and we got hold of the letter that he sent to the judges, and we were then able to publish it on social media, and now it's on the Full Fact website for everybody to see. So I think the Lord Chief Justice accepted that he had a responsibility to put things right as far as the judges are concerned. I would say the judiciary have a responsibility to put things right as far as the public are concerned, and I would say that a letter like that, a correction, should be published by the judiciary to the public as soon as possible, rather than the law officers. In other words, I think it's the responsibility of the judges when they are misreported or not reported when they should be, to do that. I think the judges have an excellent press officer, an excellent press office, limited resources, but I think they need to take a proactive step to help us. And obviously, as Brian says, telling us what sort of cases are being heard, subject to whatever reporting restrictions it's decided are necessary, would be a very good start.
Will, that was directed to you, so anything you'd like to respond to? I think. Yep, thank you.
It's wonderful getting past parcel this. I agree with everything Joshua said, as any sensible person would, and especially one with the pleasure of working with him. It's not always the case that the legal issues that reach public attention are under the control of judges, and sometimes they may be up for judges to decide. And so I absolutely agree with you that there are many occasions on which it would be good to see the judiciary take a more active role in contributing to explaining things to the public. There are probably cases where the judiciary will not be in a position to do that because it may come to them for decision. And there are cases where their role is less clear. So the first time this thought occurred to me was when the Metropolitan Police decided in their wisdom to provide legal advice to Twitter and tweeted out that nobody should retweet a certain thing. I think, and I'm going from a hazy memory, that it was the videos of beheadings that were widely publicized some time ago. And they suggested that anyone who retweeted or publicized this would be guilty of glorification of terrorism. This was a very ambitious reading of that law. And there was no obvious authority to respond to the Met overstepping its position in that way. And that's why I think that there may be, in some cases, a role for the law officers to step in. I also agree with you that there is certainly a role for judges to step in other cases. And an informed debate requires everybody with a responsibility in it to do their part.
Any other responses from the panel?
I'll just say one thing that just occurred to me listening to this. The Supreme Court now, when they're doing their judgments, quite often produce a 1 or 2 page summary of what's going to come out. And I mean, I think it's a really useful thing. It's really useful for the media because it focuses on some often very complicated legal issues, but also I think it's very useful for the wider public because again, they're not going to be able, most of them, to understand a long judgment, particularly when there may be different views expressed in the course of a judgment. And I think that's one really simple thing. Now, I know that there's also an underlying theme here, which came out in the Cardiff survey recently about judicial time available to do things. And clearly there are some issues lurking there. But I think even actually if judges aren't able to produce full judgments, producing summaries might go some way. One, to help alleviate some of this sort of concern over secrecy that comes out of people going, well, I never saw the judgment. I think it helps lawyers because it helps create a system of precedent that we're used to seeing and dealing with. And I do think it helps demystify some of these processes that go on that people just don't understand.
Thank you. Anyone else from the panel?
I don't want to hog the microphone, but Joshua's point, I think, particularly relates to what judges as a group should be doing. This is something I think we have to think very hard about. I'm not here concerned about the position of judges. I'm concerned here about the position of judges within society. I would agree personally that there would be a great benefit in the judiciary explaining what it does as well as it can using the resources that are available to it. What I don't think I or many of my colleagues would agree is that the judiciary should move into doing things that it doesn't do already. I think that would be thoroughly risky because apart from anything else, there are hundreds of judges, thousands of judges, who have a range of views. And as soon as you start getting judges coming forward in a, as it were, freelance way, then you will begin to find the obvious sorts of difficulties because one judge may not agree with another. So we are effectively in uniform, whether we like it or not. And accordingly, we have to march to a beat. I hope I don't transgress by saying that quite recently on the topic that we're discussing this evening, Sanchia was good enough to ask me to do a short piece for today, just answering a few questions and so forth. that I didn't think was the right forum for an individual judge to speak about a topic on which there is a range of views and no one consensus. That may be something that will change in the future, but I don't think that at the moment that would be the right thing to do. As to the judiciary acting as their own fact checkers, or the public's, as it were, the public's putter-writer, I think it's probably quite unusual to think of the judiciary having to put the Ministry of Justice right. That's probably not the paradigm situation that one would hope exists. Therefore, I think that much as one might wish to see it in a perfect world, as soon as the judges are expected to go out and start fact-checking, then we could get into unexpected difficulties. Could I just, while I have the mic in my hand, before going into a prolonged period of silence, I hope, just answer Brian's, on the face of it, very sensible suggestion that we should be advertising our wares so that the journalists know whether they want to come into the shop. I think that Brian's image may set up some thoughts as to whether this is right or a wrong way to be going. Now, I do know what's in my list tomorrow, and if it was to have some label on it, then it would say a case number followed by care/PII. So almost everybody here will know a care case in which there is a public interest immunity application because the information is in part highly sensitive. And the second one would say child abduction. Now, we're not, I think, going to start labeling cases any more than that. We're not able, without causing, I think, some difficulties and a workload that would be hard to carry out, to start describing the child abduction alleged and doing so in a way that attracts the interest of journalists. So if we were going to label things, I think it would be at a very mundane level. I'd be interested in other views about that, because if it was merely the question of the work involved, then clearly, if it was important, then the work should be done. But if, on the other hand, we were going to be giving more colourful labels that had more information in it, then at that point, we'd break down on what the label ought to contain, because as soon as you went further than that, then you would become potentially controversial. Thank you.
Thank you very much, Peter. Anything else from the panel before I open it up to the floor? No? Temporary silence there. Further question? Yes, down here on the front, and I'll take you second. Right.
Jonathan Pitts, I'm a legal scholar. Just responding to Peter's comments there on the lists, I think even those small amounts of information of the general area of the case, perhaps combined with an indication of at what stage in the process the case is, whether this is a final decision or an earlier hearing, is all very useful. I've not spent a lot of time in the family courts, but in the higher courts generally, the lists really are very difficult to interpret, and we miss cases which would be of interest if only we knew more than just the name and the number.
Thank you very much. Can I ask the mic to be passed to the lady to your left?
Thank you. I can only give my first name because I'm a victim and survivor of domestic and sexual violence and abuse. And my case has been back and forward through the family court for 4 years. But I've set up a group called Rise and Shine today, which is, I suppose, a group of women who feel that they are the victims of not just family court injustice, but of a system, a multi-agency system that includes children's services, domestic violence services and the family court that simply isn't joined up. We are passionate about protecting our children, and that has meant that it has been nearly impossible to protect ourselves. I come here from hundreds of miles away to represent women like myself, because I've had to leave my hometown for safeguarding reasons, and I'm not alone in that. Today is 959 days since I last saw my youngest child, and I guess I want to ask, what right do we as mothers have to hold this multi-agency set of professionals to account? We've had cases where people have tried to go through the local authority, local government ombudsman, gone all the way to the top, only to be told that because certain aspects are in the family court, that's outside their jurisdiction. And in these 4 years, trying to make every day apart from my child count, I have come to discover that there is no one agency that is responsible to women like myself to explain to us how we could have ended up in a situation where domestic violence services have intervened to save our lives, and then we've lost our lives. I've even asked for a homicide review of my case, but apparently I have to be dead before that can happen. And that seems so very wrong. Right. So my question really is, could women like us invite journalists in? We desperately want our cases scrutinised. We don't want our names or our children's names in the press. But the facts of our cases are of such vital public interest. Maybe somebody in the panel could help me to explain to the women I'm representing here today what we can do about that and not fall foul of the law. I can't even talk about our cases because I'd be in contempt. So
you don't have published judgments in these cases?
I have no idea, because these are private proceedings cases where the abuser has used private proceedings where there was no threshold and no judgments against the mothers. There's been no findings against mothers. And yet, through a series, every single one of the women I'm representing has been through crisis intervention services and has ended up where the father has been given either shared residency or residency. And that has just been the beginning of the troubles. I'm a campaign champion for Women's Aid Child First campaign, even though I'm sitting almost on the opposite side because my child is refusing to have any contact, apparently, in order to keep her father, happy.
Thank you very much for that. So, the panel, who would like to address the question just posed?
I mean, this, in a way, sums up one of the real dilemmas. Quite often, people in these situations aren't even allowed to talk to the press or their MPs. And there are problems sometimes with the way that orders are made and the way they're interpreted. I mean, having said that, Louise Tickle, who's over there, did a piece for The Guardian, was it last year now, reporting on a very difficult case. And Lucy helped her out with that case. She made an application to the judge for permission to have access to certain documents. She gave certain commitments about what she would and wouldn't publish. We legaled it very carefully. And, we were able to tell the story. And we were able to tell the story, hopefully, in a way that was accurate, reflected all the issues from everyone involved. But it takes an awful lot of time. And it took Louise, as I say, had to make an application to the court. That took time. Lucy did it, I think, on a pro bono basis for her. Otherwise, it could have cost money as well. So there's some really, just from the pure ability at the end of the process or part through the process to tell the stories, to tell these stories, it can be really, really complicated.
Anyone else from the panel? Brian next.
So, to answer the question about the lists, or generally, I think the lists for journalists are a real problem. The broad problem is that you, as in terms of lawyers and judges, know so much, and we know so little. As I had this conversation recently with Peter, who I'd come to a court case, and if we don't know what's going on, we can't even attempt to report it. And it's not really about identifying children. I'm as sensitive as anyone to the problems of identifying children, but it's in everyone's interests that we go into court. I think it's in the judge's interests that we go into court, because judges never sit in secret if me or Owen or Joshua is there. And one of the things I've noticed about family courts, ironically, I've not covered family court for very long, but one of the ironies of it is you arrive at the Royal Courts of Justice every day and you see demonstrations talking about secrets and terrible judges, but the truth is exactly the opposite. What you see in the family courts are amazingly impressive people. You do not see many more impressive people than Mr. Justice Jackson. I'm not saying it because he's here, or Mr. Justice Hayden, or Mr. Justice Holman. The truth behind those signs is the opposite. They take so much care, and that's true of barristers too. And it's not simply that we're putting children in danger. We're not really telling anyone what remarkable work judges do. And at the moment, we're relying on it's such a mishmash of telling us so. I've discovered that there are a small number of judges in the High Court Division who seem to have a great awareness of the media's needs. And Mr. Justice Jackson is probably near the top of the list and will find ways to alert you to cases. But that's not all judges. We regularly get people coming into the press room, lots of mothers, to tell us about their case. What we need is a case number. All I need you to tell me is a case number and where the hearing is. Then I can come. And that's the problem. We know there are football matches playing. Well, we don't know who's playing. And somehow, it seems such a simple problem. But it's a simple problem that someone needs to address their mind to. On a slightly different point with the lists, I think one simple solution for money fights, for divorce money fights, would be that there must be some way of allowing journalists in some, I'm not quite sure how it's done, possibly the day before, to see the lists that the staff see so we can see the names. So then, if you're representing a celebrity who's embroiled in a divorce money fight, at least you will always know that we know and we will come and you'll have to deal with the issue. That would seem to be fair. At the moment, with divorces, it's very hit and miss. So let me give you an example. I reported the case of David Walliams, the comedian, recently. And I felt very sorry for him because he didn't know I was going to be there. I was allowed to report some of it, and he settled on the second day, and the look he gave me at the end of the second day was horrible, and I felt very bad about it. And the only reason I knew he was there was because I happened to see him walking through the main hall, and I guessed where he might be going, and I followed him. Well, that's not a fair way to do it. That's not really transparent, and it's not fair. So some way there's got to be addressed. On your point about you can't tell me, I'm not sure that's not true. Why can't you tell me what the case is? Why can't you ring me up and tell me?
You want me to answer that?
Yeah.
I can answer that for you, because on every application hearing, anything to do with children's services, there is always this confidentiality clause. I remain in contempt of court. That's my understanding. It's on every...
No one would ever know you told me.
Oh, thank you.
No one would ever know you've told me.
I mean, what we're realising, and more of us are describing the experiences that we've had in these various agencies, whether it's anonymously or as named individuals, we are actually risking whatever wrath might come to us, because we have to raise awareness of these things that are going wrong, these processes that are not working, that are not joined up, and most importantly, that no one's singularly accountable for. We can't hold anyone to account. We want people to explain what has gone wrong. Well, who is going to do that job? I mean, you know, we're now ending up in the high courts. That's so expensive.
I don't want to get into any detail about legal matters because I'll just expose my own ignorance and also back up what you say about the fact that the rules are not easy to understand. But the key thing I think to remember is that protections relate to what takes place in the courtroom. There is no embargo on people telling their stories, either anonymously or anonymously if they wish to. What the protections apply to is what is written and said within the courtroom and within the court proceedings themselves. Now, it's important to remember that because the fact that something is said within the courtroom doesn't mean it becomes a fact that can't be reported if it is something that relates to things that happen outside the courtroom. So if there's any perception, and I can quite understand how it arises, is that simply because you go into a court and a family court, that suddenly everything that it's about goes off limits, well, that would be a misunderstanding. What is protected is what is said and done within the courtroom for reasons which we can either agree on or not agree on. But certainly because somebody has had a life experience, the fact that they happen to go into the family court doesn't mean they can't talk about it.
Thank you. Can I bring Lucy in here? Perhaps we can have the mic down. Thank you, Peter.
Yeah, I mean, the rules about communication of information relating to family proceedings are quite complicated. That's one of the difficulties. You are allowed to talk to your MP confidentially as it happens, but the boundaries on what you can and can't tell a journalist are quite complicated. But it's right, you can't tell them everything, and they then can't publish everything. So navigating that is really difficult, both for an individual that wants to tell their story and for the journalist that's dealing with it. There is a real issue here, particularly with the sort of system issue that you raise. So there's two parallel narratives that kind of go on as if the other doesn't exist. So the one narrative, and when I say narrative, I'm not being disparaging about it, but there is a clear strand in public debate that family courts are failing mothers who are victims of abuse, their children get taken away or alienated. That's one narrative. The opposite narrative is that fathers are being failed because the courts are discriminatory and they can't get contact or equal parenting with their children. And those are running, and it's all anecdote, and it's not properly reported anecdote in most cases. So those anecdotes may be absolutely true, some of them may be very subjective and there's another side to the story, but in terms of the public trying to navigate between those two contradictory narratives, it's really, really difficult. And we're sort of failing, really, to identify to what extent there is a system issue. How much do those anecdotes add up to? Is there a bigger issue that we need to address? And Women's Aid have been working on that a lot. They've been running a campaign, but campaign material is not evidence, and Women's Aid material is based on anecdotes, and there are suggestions about, for example, how frequently women who are victims of domestic abuse or sexual violence are being cross-examined directly by their perpetrators. There isn't actually any good evidence about how big a problem that is, and I would like to see journalists, and there are real economic difficulties with it for the press, but I would like to see more anecdotes properly reported, individual cases properly reported, but also there's a big gap in terms of statistics and research, which also, the big picture, should be reported. And I think that the family justice system is probably not collecting that statistical data to be able to place an individual story in the bigger context. So it's a really big issue. Sorry, I've gone on a bit.
No, thank you very much for that. Can we pass the mic over? The gentleman's been waiting patiently to ask another question.
Hello, Owen Bocott, I'm the Legal Affairs Correspondent on The Guardian. I'd endorse the even two-word description would be fantastic, which would encourage more journalists to go into the family courts and engage and actually report correctly and with details some of what's happening. I mean, the thing I'd say is that a lot of it comes down to resources. Being a journalist on The Guardian, I often rely on what the Press Association of Brian incredibly dedicated work on guiding us towards the most interesting issues that are coming through the family courts. And you hope that a lot of the most interesting issues are picked up. But, I mean, the problem, it often seems to me, is outside of the higher courts, in the lower family courts, where the lack of legal aid recently has meant that the experience of justice people, I think, are getting in the lower courts has been very, very unpleasant. And I'm conscious that there's not very much reporting being done even in the criminal courts around the country because of cuts to local newspapers, and probably even less, and undoubtedly even less in the local family courts. But you're having stories about judges having to separate physically fighting couples and problems of judges being physically attacked by claimants. And I think that's the area that we're failing very much in. And I ought to make time to go out and cover those cases, but it is very difficult to find those times and resources. I don't know whether other people worry about the lower courts too.
Can I just pick up that point and ask the panel? What we know is that the President's Transparency Initiative in 2014 led to there being far more High Court decisions published on Bailey, and Section 9 judges do it too. But we don't have the information from the Magistrates' Courts, which cover a bulk of these cases, particularly private law cases, nor from the County Court. What do the panel think should happen in that situation so that there is a greater understanding about the work that lower courts do in terms of the family justice system? Who'd like to take that one first? Right, just be Debbie first.
I think the difficulty is primarily one of resource. In the most circuit judges, district judges, private law proceedings, you'll have potentially two parents acting in person, the judge wading the way through it. So then to ask a judge who has little or no administrative support to produce a suitably anonymised judgment that then can then be shared, I think is well nigh impossible. I think the President has said that everybody in the family justice system is working as hard as they can, and he's not going to ask us to work any harder. The reality is I suspect we will be asked to work harder, and I can't see that there's any chance of money coming from anywhere, frankly, to support the lower levels of the judiciary in supplying that information.
Thank you. Lucy, and then who else wants to talk?
Just very briefly, just in terms of my practical experience, obviously district judges' judgments are not covered by the guidance. Circuit judges do deal with these private law cases, and the guidance does potentially cover fact-finding hearings, for example, in relation to private law disputes, allegations of domestic violence, but I don't see much of that being reported on Bailey. I think there are some real nuts and bolts issues. So the judges that type fast publish judgments, that's my view. The judges that type with one finger don't have the time. So I think actually thinking more broadly, things like training judges to type might actually be the kind of thing that would help, because we're not going to get any more money, we're not going to get any more judges, they're not going to get PAs, none of that's going to happen.
Thank you. Anyone else from the panel? Otherwise, I'm going to open up another question over here to...
No, I just had a quick question. I understood that in care cases, the local authority would pay for a transcription. Is that true most of the time or just occasionally? No, not generally true. Okay.
I think thought has got to be given to judges and lawyers, not thinking like lawyers. Mr. Justice Jackson and Mrs. Justice Tice, I remember. I'll use Mrs. Justice Tice's example. She published a judgment. I can't remember the name of the case. It was a damages case against the local authority last year, where she summarised the judgment in about 6 paragraphs, and then she went through the details of the judgment. Mr. Justice Jackson does it. I think one solution may be to start to get judges to think about better to publish something than to publish everything, and have some kind of training in writing a summary and publishing the summary as a start. I'm not saying it's ideal. I'm not saying that often the most interesting things in judgments don't appear in paragraph 79, but I think it's a start. I think part of the problem is that judges are lawyers and they think like lawyers, whereas journalists think differently. You've got to start. To give you an example that will make you smile, the Press Association was involved in a discussion with Mrs. Justice Eleanor King a couple of years ago about whether we could publish a fact-finding ruling. So a man had been convicted in a criminal court of killing a child. Mrs. Justice Eleanor King's fact-finding ruling was published on Bailey anonymously. I worked out who the parties were. and it contained some information that hadn't come out into the public domain. And so we had a hearing, and we suggested, or Mike Dodd, our legal manager, suggested, well, the answer is for you to publish 2 judgments. Give the parties your full judgments. Just publish a redacted judgment. And everyone agreed with that. And Mike Dodd said, I was sitting in the press bench, Mike Dodd said, we'll do the redactions, it's no problem. And it's just as Helena King said, that's very kind. How long will it take? And Mike looked at me and said, are you busy? And I said, no. And he said, Brian will do it. Give him the time to have a cup of coffee in 20 minutes. And she said, gosh, I was thinking about 3 weeks. And it's an example of, Dylan said, we all see the same. We just see it from different points of view. And it's an underlying trend that if you let journalists into family courts, we're not seeing what you see. Judges have brains the size of the Milky Way. I've got a brain the size of our Milky Way. We see it differently. What we see is not what you see. And I think a part of the help has got to be, possibly from the likes of Peter and Mrs. Justice Tice, to say you can get information into the public domain. It doesn't have to be everything. And I think there's got to be a sort of different way of thinking about it myself.
Just to add to that as well, I mean, there are 2 ways of doing anonymous judgments. You can try and write the judgment so that it has no facts that are going to give away who the people are. Or you can write it as you would write it and just block redact. And judges have been doing that recently. The Supreme Court judgment on Brexit had 2 paragraphs that were pretty much redacted out. There are ways in which you can do these things that don't mean that you're having to reinvent the wheel in order to get something out that is acceptable and useful to people. So again, it picks up Brian's point that thinking a little more outside the box, the traditional box of these things, is something that I would encourage.
And there was a guidance published and funded by Nuffield in July of last year, which gave judges guidance on how to anonymise judgments. And there's suggestions in that about having aspects of it that wouldn't appear in the published judgments, particularly details of sexual abuse, which one wouldn't want necessarily to be in a published judgment, but do need to be on the record. And by that means protecting children from potential further abuse, or being, in the event of any identification, there's less information out there.
Thank you. Right, going to open it back to questions from the floor. Patient there down to the bottom. First, gentleman at the back, Martha at the right, and then lady at the front, and I can't take any more hands at the moment, so you can put them up again in a moment. So lady over there.
Hello, I'm Louise Tickle. I'm a freelance journalist, and I try my best to report on these matters. The point that I would like to make, both to this lady here and to people on the panel, I would really love your response, is what's a journalist meant to do when the very thing that you're trying to report on is allegations of things not going well in court, if we're not allowed to report what goes on in court? There have been numerous occasions, but I can think of 2 particular ones in the last year and a half, when in the wake of all of the Women's Aid campaigning and a great deal of coverage in the press about not just cross-examination in court of domestic abuse victims or alleged domestic abuse victims, but issues to do with access to children, and there was the whole Rebecca Minott case that happened in Bristol, which I kept very close tabs on. 2 women have approached me saying that they would really like me to come and sit and could I cover what was going on in their case. Now, I have no stake in those women's cases. I'm not Women's Aid. I'm not a lawyer. I'm really interested to find out and do that down in the weeds digging of what does, in practical, real terms, happen. Now, I appreciate this is not going to be an academic study. This is going to be a reporter's view of what is going on in a particular case. But I cannot do that. And in one of those cases, where I had said to the woman, out of interest, I will come to see, even if I can do nothing on this case, she was then just too frightened to let me go for fear of what she felt would be the judge's reaction to my presence in the courtroom, even though, subject to objections, I have the right as a journalist to be there. So the question is, what do I do as a journalist when the problem I'm trying to report on is an issue with the court process, if I cannot describe the court process?
Anyone from the panel would like to take that challenge?
What was the case you said? I was Rebecca Miller.
The case that I was asked to go to was not Rebecca Minnock.
Minnock. Sorry, Minnock. Sorry. I don't actually understand the problem. If a member of the public, it's happened often, tells us that they've got a court case and they're concerned, I will simply go to the court, argue that I have the right to listen, and then argue that I have the right to report certain things. And my experience of judges is that they're invariably sympathetic, understanding, obviously intelligent, and we report. I mean, the gist of reporting family courts is not essentially different from reporting Crown and Magistrates' courts, where you're dealing with children. In a Crown Court case where you're dealing with a child covered by a Section 39 order, you can't identify the child. Broadly, in family courts, it doesn't change, but I don't really think it stops you reporting the issues. I mean, I don't know whether Peter would say differently, but I've turned up lots of times in courts having been told by members of the public of a concern, and simply go and listen. And one of the interesting things in family courts is that the work you do is so interesting that there's always something to report. It's always fascinating. So I would say, go to the court, stand your ground, and argue with the judge, and report what you can.
I would just like to say, the day after we were allowed as journalists to go into the family courts, I spent some time going around, seeing what cases I could report. And even from the first days and weeks, you could report what was happening in court if the judge agreed. Everything I would make sure that the judge knew that I was there and talk to the judge about what I was planning to do. But even from the outset, it seemed to be quite possible to do it.
My understanding is you can report the general gist of the issues, but I would want to be reporting the absolute nuts and bolts of what went on, how people spoke to each other, the way the judge was addressing the parties, the way the barristers were speaking, the kind of questions they were asking. That's the kind of feature I do. It's not news.
Well, if I can deal with that as best I can, I don't see any problem with that at all. The difficulty would be, I think from any judge's point of view, would be just knowing that you weren't going to do it in a way that would identify the people in the case. So if you've got somebody, in a sense, who's made a story outside the court already, then it might be harder to report what took place inside the case, because you wouldn't then be able to separate the two. I do think a good point was made earlier on about local courts, because in the courts in London, where such few journalists as there are who take a close interest in this reside, and where the judges are used to having the journalists in front of them, I do think that a level of mutual trust and respect has developed. I think it's much harder in the local courts, and I think that if you want to achieve something similar, I mean, no doubt improve it as well, but something similar in the local courts, that journalists are going to have to get out a bit more. The judges are out there. They're doing the work. They're doing far more work than is done in the centre. And in my opinion, it's much harder. It is much, much harder to deal with a case involving two very angry, unrepresented litigants in a small room on your own than it is to do so in a large court with at least some lawyers from time to time. So I can quite see why your individual may have hesitated to bring a journalist into court, because it might be misrepresented as being just another unhelpful thing to do where the children were concerned. But if it's set up properly and you make clear that you're not interested in exposing the family, but what you're interested in doing is looking into the process, if the individual judge was not to agree to it, then I think you could quite possibly take that further. I know that, I'm sorry to have spoken for so long, because just looking down the room, I can see that there are a load of people who've got questions, and I just hope that we manage to get as many.
We'll take Dave very shortly, and what I'm going to do, because the questions, I'm going to take 3 questions at once, and then we'll open them to the panel rather than one and one. So we'll just let Dave finish on this one.
I'll be brief, Joe. Louise, I was thinking that the local family courts are, to use a sort of slightly slang word, much more random about these things. And so even in the example you gave, the mother wanted you to go, but wasn't sure either. And I just think we need to recognise that for families and for children, this is a process that is deeply affecting. And, bringing a journalist or not bringing a journalist and what the implication of that might be, I think for many, many families in the court system, it's unclear as to whether that is a helpful or unhelpful thing. I'm sure most families would agree after the event, a sort of reflexive piece of reporting on what happened and what the issues were. I think most families would get that. But in the moment, I think it's a very difficult thing to do.
Can I just add one thing on that, because I think it's important. I assume that there are quite a lot of lawyers here today, and one of the issues for me is that the lawyers who are acting for the parties also take on some responsibility in this process. I mean, I've had cases where we've gone down as the media to try to challenge a reporting restriction order, and the parties have tried to stop me going into the court because I'm an in-house lawyer for a media organisation. There's an enormous amount of prejudice and misunderstanding around these things, and I think it is lawyers should be obliged to think a little more carefully about these things and be a little more responsible about their approaches to these things. And just a very short example, the number of times when we get reporting restriction applications through that lawyers, and quite often it's a local authority, won't tell us the names of the parties. And we write back and say, you've got to tell us the names of the parties. Without that, we can't do anything with this reporting restriction. We can't even tell our internal clients what they can't do. And they're going, well, we're not going to tell you. And I mean, that level, I'm afraid, of ignorance and obstruction is just got to stop and has got to change.
Thank you. Can I take a question from the back there? Lady directly in front and then Dave to the right.
I'm Martha Cover. I'm co-chair with Debbie of the Association of Lawyers for Children and a barrister who specialises in child protection. The children that go through the family court system have all suffered. The great majority of them, in fact, will have suffered significant harm or will have been likely to suffer significant harm. And although there is undoubtedly an enormous public interest in greater public knowledge about what happens in the family court, and even greater interest in the human stories that lie behind those doors of Brian's shop, the fact is that we have to adopt a child-centered approach to this, and the rule must be do no more harm. And the difficulty of actually managing that is demonstrated very graphically by the young people from the National Youth Advocacy Service who took 21 judgments, anonymized judgments from Bailey in family cases, and in 7 of those judgments, within a period of hours, with levels of computer skills and social media skills that I have, frankly, put me completely in the shade, they were able to identify those children and those families from jigsaw identification, from cross-referencing to criminal reports. Don't forget that a lot of the child protection cases that you most want to report, and which I agree the public ought to know about, are concurrent with criminal proceedings. So cross-referencing all of that material, they could identify those children by their family makeup, by their religion or ethnicity, by the area in which they live, by some detail about the school which they attended, or about the particular shape and size of their sibling group. They identified 7 out of those 21 carefully anonymized cases. The second thing that they were horrified by was the level of detail, particularly in cases of physical and sexual abuse of children, that the judge needs to set out in order to explain his or her findings about specific matters alleged by the local authority. And that is a shame and a humiliation for them that is there forever. Of course, it's not yesterday's chip paper. It's there forever on the net. And they were appalled by that. Therefore, there is no substitute, but it seems to me, having wrestled with this issue for years, but for judges to have to write 2 judgments. And what I fear is that the stripped down, bare, and truly anonymized summary judgment is not what the press wants, and it's not what the public wants. They want the human story that Louise Tickle was just talking about, of what's actually going on in that courtroom on a daily basis. And that's something that we must grapple with. The children have to be put first.
Thank you. Less of a question and more of a speech, Martha. So I'll take the question from the lady in front and then David to the right.
Thank you. I'm Jo Edwards. I'm the immediate past chair of the Family Lawyers Organisation Resolution, and I'm a family solicitor. Bit of an anecdote, and then it will become a question, I promise. Last week, the end of last week, it was the Resolution Annual Conference, and Mr. Justice Kean, who did the keynote address on this very topic, spoke incredibly warmly of Brian. And the role that Brian plays in the family courts and responsible reporting of cases. And he told a particular story of one day, I think it was he himself who'd written a judgment, and Brian had contacted him and said, actually, through a bit of Googling, one can identify the family in this case. Therefore, you may want to look again at your judgment and republish it. So really, there's been a lot of discussion this evening about the role of judges, the role of lawyers, the fact that we're perhaps all being a bit weak and lily-livered about this. But I'd like to bring onto the floor, really, the question of the role of journalists, because obviously we're surrounded this evening by some very august, very responsible journalists. My concern is, as we move through the spectrum of what we have at present to increased transparency in listings, to the potential of more documents being released to journalists, to eventually potentially very much more public hearings, relaxed reporting restrictions, how can we actually guarantee, how are we going to protect our children against irresponsible reporting, against irresponsible journalists who aren't like those in the room tonight? Really, how can we protect against that and ensure for our children that they're not identified in the way that we're all very concerned about?
Thank you. Take that to David, and then we'll wrap the questions.
Yeah. David Williams. I'm a family lawyer and part-time judge. I think there are, as Peter said, we find ourselves between two extremes. One, I think it is something the press can look at. I think there's a lot more they could do to help with the transparency project. First of all, why can't the press as a group fund a project to get journalists out into the local courts where the majority of this sort of work goes on, and to report what the reality is in 99% of the cases that we deal with in those courts and report back? I mean, the press makes a significant amount of money, I guess, from reporting on legal issues, and I think that would be a way of putting something back. I think the other way they could put something back is to educate us lawyers, because I think as lawyers and judges, we don't appreciate fully the needs of the press, and the point was made that a lot of lawyers seek to obstruct the provision of information into the hands of the press. And I think partly that is simply because a lot of people don't know about it. And so I think there is work that could be done by the press in going to lawyers' conferences, social work conferences, etc., to educate those who are involved in the system about what they can do to help. I think on the other side, what can the judiciary do? I mean, most people are interested in local stories. Of course, the big ones hit the headlines, but actually what most people are interested in, what's going on locally. And I think that there's a case to be made for the judiciary going out to seek to make the case for the family justice system by the circuit judges and the district judges, giving interviews to local radio, giving interviews to the local papers. They're usually desperate for material to put in them because they're so short of funds. And I think that's something that the Judicial College could look at.
Thank you. Right, so 3 points there. Martha's powerful reminder that the children at the heart of the process shouldn't be damaged by the press interest and publications. Secondly, a question to those of the press on the panel about what the press can do to balance out the misinformation and potentially mistrust at the lowest courts. And then thirdly, from David there, what can the judiciary and the press do collaboratively to make sure that the initiatives at the High Court level are rolled out in local courts? Who'd like to take that from the panel? Will?
To talk as, if you like, the outsider to journalism who also has a journalistic hat on, I think the powerful statement that the needs of children need to be put first is compelling, and the difficulty is the short-term and the long-term needs of children. Everybody has an interest in being able to scrutinise how power is used, including the power of the courts, and there may be a tension between both of those. There is certainly no possibility of living in a world where responsible journalism is guaranteed. And actually, when you look at what the mechanisms of doing that would look like, you don't want to look in a world that's trying to do that. This evening has been a fantastic advert for what great journalism is and what it does. And I remember one of the many pieces of evidence we gave to the Leveson inquiry was highlighting the collapse in specialist court reporting and the damage that does to our courts, as well as to our reporting. That is continuing because there isn't money in journalism. Actually, by and large, The Guardian, well represented in this room, is becoming increasingly less well represented in staff, and it's not alone in that. So great journalism can make a huge contribution to the courts, but there is not a kind of pot of gold at the end of a rainbow from journalism to help solve this problem. One thing that we need to do, therefore, is to challenge bad journalism. And I believe that's the responsibility of high-quality journalists, as well as it is the responsibility of the rest of us. One of the reasons I'm proud to be involved with Full Fact is that we are led by people who have had senior roles across all parties in politics and in journalism. They believe that politics and journalism deserve to be done well, and therefore we should celebrate the good and challenge the bad. I think there is maybe a gap in the market here, which has emerged in several comments, for serious social research and serious insight into the courts. Journalism cannot systematically look across the family courts and find trends and identify in a reliable way, you know, what is going on. It can give impressions of that prompt further investigation and further action. There is maybe a cause for much more statistics and much more research into what is going on in the family courts. And I think that is something that judges could look to enable. It is entirely possible to record whole swathes of hearings in a completely confidential way and use those recordings to look for systematic themes where further action may be needed, where there are concerns. And that kind of highly confidential, highly sensitive social research is routinely done in lots of challenging fields. I think there might be a case for more of that to sit somewhere in the middle of what journalists can do to make family law better for everybody affected and what judges can do for the same ends.
Thank you. Given that very full answer from Will, I'm going to open it up to questions more from the floor. Anyone else want to? Lady there in the front, gentleman there.
Hi, my name is Penelope Gibbs from Transform Justice. We have a situation where in the criminal courts, children are not often, but sometimes identified. These are children who are convicted of crimes, but very often they have high welfare needs and have been involved in care proceedings themselves earlier in their lives. I was just wondering how the panel felt about the issue of the dichotomy between the family courts, where the children's identity will always be an effort to protect it, and the criminal courts, where that's not always the case.
Thank you.
Hi, I'm John Oxley, and I'm from Vardags, who deal with a lot of high-profile financial cases. We've talked a lot tonight about the things we say as lawyers, judges, journalists, but looking at the problem from the other way around, in a world where nuanced explanations tend not to drive website impressions, how do we make sure people are listening to the things we want them to be listening to?
Right, one more to add to the trio at the back there.
Thank you. I'm Philip Marshall. I'm chairman of the Family Law Bar Association. I was involved in a case quite recently in the Court of Appeal that attracted a good deal of media attention, and that was the defended divorce case, which is ongoing, and I don't talk about the details of the case. But the thing that struck me, and of course that was a case that was entirely in open court, and in relation to which there were virtually no reporting restrictions, save some very ancient reporting restrictions that really didn't arise. But the thing that struck me was the almost complete absence of press in the courtroom on the day at the time. There was a reporting frenzy afterwards, and indeed, as you know, the case attracted enormous and wide publicity, and has done recently with the judgment that was handed down by the President. By contrast, other cases in which I've been involved, for example, the Young and Young case a few years ago, the man who lost 460 odd million pounds of assets, as it were. The reporting interest in that case was huge. I mean, I think I counted on one particular day, there were between 15 and 20 journalists in court, all anxious to report the minor detail about what these people were spending on what, and what was alleged to have been frittered away on each side, and at what sort of level. And we've seen it even more recently, of course, in the Jafali case. And I do wonder where the balance is to be struck between a legitimate interest and entitlement to report what's going on in the family courts, to ensure that the family justice system is operating in a proper and fair and balanced way, contrasting, on the other hand, with the reality on the ground, which is an over-interest in middle-class sensationalist divorce, which simply fills column inches in the way that the Jafali case and others of which we will all be aware do week in, week out on a national level.
Right, so 3 issues there. The first was similar facts in crime and care. How does the family justice system report to that? That may be one right up Peter Street. Secondly, do we give the public what they want or need in terms of press reporting? And thirdly, what makes the press nose a quiver when they hear of a case in the corridors of the family justice system? Peter, given your experience with one particular case, I think you're in prime position to deal with the first matter.
I'm not sure I'm going to directly answer in that order, but Martha said something that is so reasonable that none of us could possibly disagree with it, which is, above all, do no more harm. I actually don't agree with that. Of course, if one was only concerned with the interests of the individuals involved in the case, then it would be easy, because we'd simply just shut the doors and never open them at all. This is all about striking a difficult balance, and bearing in mind that some children may have to suffer some more harm in particular cases in order that all children or all families should have some chance of being part of a credible system. And so you're not comparing like with like there, you're dealing with something that's much more difficult. In cases that have a criminal side to them, anybody can find out which family is concerned, unless you were to tell the story in a way that was completely pointless. It's not possible to do a judgment in a care case that is not linkable with any serious criminal case. And does that mean that we never report those cases in the family court? Of course not. We have to take the risk that there will be some jigsaw identification. Likewise, some of the publicity that is most feared is local publicity, not rather than national publicity. Because, of course, if you know that you're in Barchester or Borchester or whatever it is, then if the story is a Borchester story, then you're more likely to be identified. So the people are not just scared of the red tops. It's the local papers as well. Does that mean we're not going to report local papers, local stories? It shouldn't do. I also may be out on a limb on this, but I have an unease about the possibility of airbrushing abuse. I think that if a judgment is going to be published, then one has to try not to be unnecessarily pandering to people who might have a salacious interest in reading it, if anybody ever reads the judgments at all. But the press certainly don't publish those sides of it. But I personally object to being told that I can't put in a judgment the terrible things these children have gone through. And to take a particular point, the research which was referred to earlier by Julie Brophy, took up one of my judgments as being a very bad example of putting in nasty things. And the children who read about it thought that it shouldn't have been said. The children in that case, as it happens, it came to me by a side wind, who are teenagers, reported back that they were delighted that the judgment had been published because finally somebody had listened to what they had been going through. Now, whether that translates to doing the judgment in exactly that way, I don't know. But I think the idea of putting all the nasty bits in a schedule will cause at least as many problems as it solves. I'm just very quickly going to say this. If members of the press want to go into court in order to see how the court works rather than to follow a particular case, I would have thought they should get in touch with the press office, who will very readily find them a judge who will be willing to have somebody sit through a day and will explain to all the people in the case they don't have to worry about it, they're not going to be identified and so forth. There's no obstacle that I can see to that at all. And finally, as to the last point, which I think Philip Marshall made, why do journalists come to cases about rich people and celebs? They're perfectly entitled to do that. I don't think we should be trying to educate the press into what is and what is not of interest. Some of it may be silly and trivial, some of it may be very important. That's up to them as far as I can see.
Thank you. Anyone else from the panel? Gill.
I'll just pick up on Peter's last point, because there's a 19th century rhyme that became the title of a book by Matthew Engel about the popular press, and it goes like this: tickle the public, make 'em grin. The more you tickle, the more you'll win. Teach the public you'll never get rich. You'll live like a beggar and die in a ditch. And I'm afraid that sort of answers that last point.
Thank you. Anyone else for a panel before I open it up? Lucy? Brian?
Can I just answer Mr. Marshall's question? It boils down to, because I covered the case, it boils down to what I was talking about the list. I don't think I covered the young and young hearing that you're talking about. I suspect the reason there were however many journalists were there and there was that they knew the case was on the diary. It had been reported before, so they knew. The Owens case you're talking about, the reason I was there was because I happened to notice on the Court of Appeal list that there was a list of a name versus a name, so that told me it was a divorce. It had two very eminent family judges on the panel, so I thought that might make it interesting, and partly because I saw you standing outside. And that's the reason we went into that hearing. Until I happened to wander over past Court 33 to have a look who was around, I had not a clue who Mr. and Mrs. Owens were. And that's why there weren't lots of journalists there, because we didn't know. I think there were two, actually. And I was sitting at the back part of the time, because I was trying not to disturb the court, nipping in and out. So that's the answer. When we know, we're obsessed these days with diaries. When we know, when it's on the diary, everyone goes. There's an interesting example at the moment. I've been doing two jobs in the family court this week. One in Court 47 and one in Court 49. They are almost identical cases where judges are asked to make decisions about the treatment of seriously ill children. One case, the family went to the press, launched a GoFundMe appeal, launched a Facebook appeal, want the child reported. So if you look through the window of Court 47, it is heaving with journalists. In Court 49, there was only me, because the family don't want the name revealed. There's an order, we can't report it. And that shows, I can't remember the judge who said it, what's in a name. A lot people want names, and that's part of the reason. And ironically, none of the journalists wanted to walk next door just to see what was going on, although that was sitting in public too. So it's part of the problem. When we know, we will go. And while I was just here, I thought Peter made an interesting point a little while ago about local coverage. The underlying problem with family courts compared to other courts for journalists is that there's a starting point in the criminal court system. So if I steal Owen's pen and run out of the door, the police will catch me and I'll be charged, and they'll say, Brian's been charged, and he's appearing in magistrate's court, and it begins a trail. So you can follow my case as I go from the Magistrates' Court to the Crown Court. Similarly, in other kinds of cases, if I libel Owen, Owen will say, I am going to sue Brian, he's libelled me. When are you going to come to court, Owen? Next week? We can follow it. The problem with the family courts is that there's no starting point. So we have no idea what Mr. Justice Hayden's doing because there's no starting point, and that's the root of the underlying problem. And the difficulty for local newspapers is it's partly a problem of the press, I think. When I started in journalism, which was, I don't know, I can't remember. I remember covering the invention of water. It was in the early 1980s. Well, I started on a weekly newspaper called the Westmoreland Gazette, which is based in Kendal. And we had probably 10 reporters, and we religiously covered Kendal Magistrates' Court, Ulverston Magistrates' Court. I went to the police station every day. And I'm sure if the rules about family courts had been the same there, we would have religiously gone to the local family court. I went there for Christmas last year. There are now 2 reporters on the Westmoreland Gazette. I don't think they ever go to Kendal Magistrates' Court. It's not really a problem for the justice system. It's a problem with the press. They're just not enough, and that's the difficulty. It's simple things that cause problems.
Right, now we're running out of time now, so I'm going to take the last 3 questions from the floor and then open it up to the panel to respond.
Hello, I've been a Mackenzie friend for over 11 years, and I've actually sat in many, many conferences like this. The first one was in 2007 when Lord Laming actually produced a consultation report called Opening Family Courts. In 2009, the then Justice Secretary Jack Straw did a debate in Parliament on the 9th of December 2010 saying we're going to put new legislation out there for media to attend family courts. 2010 it actually became statutory instruments. And here we are now in 2017, almost 10 years later, and we're still having these same debates. So is it actual legislation we need that covers everybody, every orifice of transparency of family courts, or what is the actual solution we're looking for?
Thank you. 2 other questions from the floor.
My name is Caroline Little. I'm a childcare solicitor and have been for about heading on 40 years. I'm quite disturbed by some of the things that have been said on the panel, that really children need to be sacrificed for the greater good, the short term for the long term, I think is the way Will put it. As a childcare practitioner, meeting young people and representing them through the court process, do we tell them then that it doesn't matter what happens to you, it doesn't matter if you're identified, because it'll be better for the judges and the system if you are?
Thank you. And question from behind.
Hi, I'm Elizabeth Cape Cowens. I'm also a childcare solicitor. I agree with what Caroline has raised, but in addition to that, the question that's been going on in my mind throughout this debate tonight is, I think that there is a separation between reporting about the family justice system and reporting about the details of individual cases and sort of, interest in the lives of people that may, make fantastic headlines. And I agree that it is necessary to get the word out about how the family justice system works. And also, I think it is important to review when things go wrong and to point out when things go wrong. And I think there do need to be mechanisms put in place to do that. But I just wanted to ask, does it need to include the individual details of cases, or can it not just be about the court itself and the decisions themselves and how they work? Why does it need to be about individual cases and reporting all of the stories about individual cases when that may harm a child?
Right, thank you. So over to the panel. Is it time that we had legislation? Do we sacrifice an individual on the altar of public good, and how much information do the public need?
Can I just, on the question of why can't you just tell people how the family courts work? people aren't really interested. They're not really engaged. It's the story again. It's, one person. You can tell a story very well without very much identifying detail. A lot of the judgments, Peter Jackson's judgments particularly, they lend themselves to that. But it's about your reader, your listener, being able to identify with the people that will make them really pay attention and care about it.
I mean, it's a criminal offence if the media identify a child. That's the position. And the media, at least on my side of the spectrum, work extraordinarily hard to make sure they don't. I mean, not just in terms of the obvious detail, but we do these Google searches in order to try to make sure that even if stuff's in the judgment, it's not going to start leading to people being identified. The last thing most of the responsible media want to do is identify a child, but they do need to tell the stories. I'm afraid, I entirely understand why people would prefer that the media wrote about the system, but if they write about the system, no one's going to read it. And the way you try to educate is through the storytelling of the facts of cases. There's, as has been said, it's a difficult balance. I think you have to try to trust the responsible media and to some extent help them to tell those stories. And if the lawyers and those people who are, educated and informed about these things engage with the media a little more, I think it makes it easier. And going back to the question about is legislation the solution, I don't think legislation is the solution. What is the solution? As I think I said from my perspective at the beginning, is that this is a shared responsibility of all of us, as lawyers, as journalists, as the parties themselves, as the judges. And we all have to try to work together. And on one level, having these sort of dialogues and trying, hopefully, to persuade people. And I can understand if you've been a childcare solicitor doing that job or a barrister, how soul-destroying it can be and how awful it can be if you see some story plastered across the pages that you think is just not telling the story correctly. I entirely get that, but there's a societal issue lurking in all this that we have to work out. And if people who are using the court system are just failing to understand what it involves, the issue about the parents who don't want the media there because they think this is going to happen or that's going to happen. We've all got to try to work on all sides of the equation to try to reassure them and to try and make sure that those things don't happen. And if they do happen and the media do abuse that responsibility and that power that they have, then there are ways of holding them to account. One of the things, and ever since the family blog has come out every week on that, the first one or two that came out, there was a criticism of a Guardian article in there, and I went to our journalists. That was voluntary. Nobody'd come to us directly about it. And I went to her and I said, look, somebody's raised a question about this and said we've got it wrong. Let's go and have a look at it. And we went and had a look at it and we made some corrections to that story. Now, I cannot say that every media are going to do that. But if you start and you start challenging them, then you will start changing things. Lucy?
I suppose the thing I want to say is that there are examples of good, solid anonymisation out there. We've just got to get better at doing it. We've got to do it more reliably. It's not a question of stopping doing it. We've got to get the information out there in a safe way. And I think a lot of the issues that have been raised today are about our lack of familiarity with these issues. So local courts, there's a lot of lack of familiarity both with the anonymisation process, because people don't do it very often, they make mistakes, they're frightened of it, they don't think of all the things that they might need to redact. And there's a lot of fear and hostility when people turn up in court. I can remember on an occasion when Louise turned up in a hearing, I think the only time I've ever had a journalist in court when I've been in a local court, my opponent said to me, "Did you tip her off then?" And that's what you get in a local court. So if I was a parent in a local court, I would be worried that people would say, well, why have you brought a journalist into court? It's about familiarity. And when we're unfamiliar, then there's a lot of fear. And I think we've got to be really careful about distinguishing between cases where there has been demonstrable harm caused to families and children and the fear that we have that might happen. And the big issue for me is that we are harming families and harming children if people are not able to engage with a system that they don't trust. We can't talk about the detail of the Samantha Baldwin case that's ongoing at the moment, but if you check social media and you look at what people are saying, they are saying being a mother in those courts is like having a water pistol against the British Army. Family court, #joke, #bent judges. They're talking about corruption. They're saying the justice system protects paedophiles. They're telling her to keep running. And they're saying that the family courts are a disgrace and they only make gagging orders because the courts have got something to hide. We've got to do something about that, and we have to tell those stories, and we have to tell them safely, and we've just got to keep plugging away at doing that and doing it more often and getting better at doing it in a way that's safe.
Right, thank you. Now I'm going to call a halt to the questions and answers here.
I'm sorry, can I just respond to the question that was directed to me?
Yes, of course.
Because you kindly gave me an opportunity to clarify what I was saying, because I'm absolutely not suggesting that the goal or even an acceptable outcome of trying to make the family courts reportable is to sacrifice one child on the altar of what's better for judges or anything like that. What do you tell the child in the courtroom about why a journalist is there? Perhaps you tell them that they are there so that if the court mistreats you, they can make sure that it never happens to another person. You tell them that in the past, when the courts have been closed to everyone and to outside scrutiny, they haven't served children very well either. This isn't an easy balance to get right, and it's not a balance with perfect answers, but it is a balance that needs to be struck, and there isn't one right end of the spectrum to aim for, but we have to recognize that transparency to some extent, scrutiny to some extent, are things that help secure the welfare of people involved in the court system and of children. And they are not things that go against that all the time and in all circumstances.
Right now, you'll be able to field questions and get answers at the conclusion of the evening when we go next door. But can I just... Yes, of course you may.
It was just an answer to this gentleman's question about legislation. Not that I'm aware of, but what I am aware of is that the President of the Family Division will quite shortly be reviewing and probably revising the guidance that has gone out so far. And that, I think, is probably going to be the next step from the judicial point of view. And there will undoubtedly be some changes to the guidance that's been given. And I personally, insofar as I'm able to carry back what's been said this evening, or what will be put up after this, I take a number of points that are likely to be relevant to that exercise.
Thank you. Now I'm going to look to make sure I look to my left. It's one of the problems of being 5'2" and trying to peer over. One of the reasons Lucy wanted this evening to happen was to have a proper dialogue between lawyers, judges, journalism and the public, and I think that's what she's achieved today. And just by virtue of some of the constructive suggestions, potentially having lists published in advance so that there is no ambush mentality on the day of the hearing. Secondly, having a really short description of what the case is about, together with whether it's interim or final. Thirdly, having a summary of judgment that might be able to stand in favour of a very long, full analytical review of the family's history. And then maybe mainly it's having a trickle-down dialogue at all levels of the press and the judiciary, so that the mistrust such as it exists is broken down by understanding what each wants to get out of the system of the children or the families who are at the heart of it. And with that dialogue, you'd have the same level of respect that clearly we can see operates here at the High Court. So I'd like to thank Lucy for inviting you all here this evening. I'd like to thank the panel, both for their time, their energy, and for the enormous amount of experience they've brought to the questions you've given. And before we close, can I hand over to Lucy, who's going to talk to you about the media guide. But please don't rush away, because when she's finished, you're invited next door to a glass of something cold or a glass of something hot, and you can carry on the dialogue in a more informal environment next door. So I'm handing over to Lucy to wind things up, and thank you very much for your time and attention.
Yes. I'm going to keep this very, very short because it's been an interesting but quite intense discussion. You've got a copy of the media guide on your seats. It's one small part of a bigger picture that we've been discussing today. It seems to me that There are lots of small things that we can do to move this forward incrementally in a way which is appropriate. And one of the things we've been trying to do, as Gill has indicated, is we're learning about how to work constructively with the press and not just bash them over the head and say, you've got that wrong, that's rubbish. So we're learning about that, and we're trying to produce tools and be useful to the media, particularly inexperienced journalists who might be in local courts and who want to go out and report these cases, but are a bit iffy on what they are and aren't allowed to do. When I went and sat in on one of the contempt hearings in the Rebecca Minute case, there were journalists outside from local newspapers saying, "What's a Guardian?" So there's a role there, we thought, for a document that just spelt out the basics of what the parameters are when you want to report in family courts. It's not a legal document. Hopefully it's not in code or legal jargon. It's not legal advice, and it's not overambitious. There are far more detailed documents that have been produced that will give journalists the real nuts and bolts and the real detail. That's not what this is aiming to do. It's a small contribution to try to help people to facilitate more and better reporting of family courts so that people know what the framework is. It's available on our website in PDF form and in an online format, so people can come and look at it and download it and refer to it when they want to. We're very open to feedback on that. We tend to draft collaboratively at the Transparency Project, and we do update our documents when people give us constructive feedback. I want to give some particular thanks to Paul McGrath, who's sitting in the middle, who's been our microphone man, because really the media guide is his baby. We have drafted collaboratively, but it's pretty much Paul in this particular instance that's been responsible for putting it together. So thank you very much to Paul and everyone else that's contributed. I want to say thank you very much to Jo for being such a fantastic chair, and to all our panel on behalf of the Transparency Project. And please come and have a drink, carry on the conversation with us tonight. Please keep tabs on what we're doing at the Transparency Project. Suggest things to us that we should cover. Help us out if you want to. If you want to contribute guest blog posts on things that are bothering you about family justice, please do. We welcome a multitude of voices so we can have debates about family justice, and we will host them on our website. Thank you very much for coming.